Hello and welcome to another edition of Think Legal. Oh man. So I do a podcast and I've been working on that yesterday. And so I'm used to doing things a little bit differently. So I wanted to, I realized I was, anyway, today we're going to talk about if you are personally liable if you are sued. And the answer is there are some cases that might be true. And we're going to talk about those. So please stay to the end to make sure that you're getting all of the right instances in which case that could be. If you're new here, my name is Taylor Darcy with Think Legal, and I help you create the business of your dreams. Now, the reason why this topic is so important is because there's a lot of misconceptions about if you start a business, limited liability company, or a corporation, or any of those types of business entities, that it removes all of your liability. And it doesn't. There are specific instances in which case you may still be liable, even if even if you do have those entities. So please keep that in mind that we're discussing this in the context of business, but it's also true even in non-business settings that you can be personally liable for your actions regardless. And so the number one thing that you have to remember is even if you have a limited liability company or corporation, that if you are negligent, you personally, not somebody that works for you, not somebody that you hire, you personally, if you are negligent, that you may still be personally liable for your negligence. Because the way it works is that the LLC or the corporation is meant to remove liability, personal liability, for things that are outside your control, outside of your ability to not do those things. So in negligent situations, if you do something negligently, you can still be sued and still be found liable for that negligence. So that's number one. So you want to be careful about what you do. You need to act as a reasonably prudent person would act under the circumstances. And that's the definition of what's required to not be considered negligent. Okay, reasonably prudent person under the circumstances. It doesn't mean that you have to be more prudent. It doesn't mean it just means that you can't be less prudent. You need to make decisions that are based on how a rational person would make a decision. For instance, a red light. Don't run through a red light, right? I mean, the idea being that is presumptive negligent. You have a red light, you don't run it. That's how you avoid negligence. It doesn't necessarily mean you have to be overly cautious and stop on a yellow necessarily. Although ideally you should. I mean, yellow means, or orange means to slow, right? But the idea being that you want to be reasonable in your behavior. Another one that's very common as a business owner is if you are signing a building lease or other type of contract, and they ask for you to sign what's called a personal guarantee. Under those instances, if you sign a personal guarantee, you may be personally liable for that contract, whatever it may be. If it's a lease, if it's another type of contract. And a lot of times lease owners want you to sign that personal guarantee as a way to mitigate their risk in a contract, in a lease, because especially if you're a new entity. If you're an older entity, if your business has been around for 10 or 15 years, 20 years, they may not require you to sign a personal guarantee. If they have you require a personal guarantee, and this is important, you want to make sure that there's some way that you can either reduce it to over time from 80% from 20% from 100% to 80%, 60%, 20% to no liability after a certain period of time. Or there's a mechanism that reduces that personal guarantee over time. It doesn't necessarily have to be that. There are different ways and mechanisms that you can use. But you want to make sure that people that you have that you're not personally liable forever. The other thing is you want to be careful, and what I would recommend doing is paying a higher rate to avoid that personal liability in those instances, because or finding a place that won't require you to carry that personal liability or personal guarantee. That way, because no matter how good the place is, if like I ran into this with a client of mine earlier this year with the pandemic, he signed a lease right before the pandemic and he couldn't even move in, and he had personally guaranteed the loan. And that's a really terrible place to be in. So you really have to be careful of the personal guarantee. A lot of leases want you to sign that. I would avoid that at all costs if you can avoid it. It's got to be a really, really good place for you to do a personal guarantee. Now, if you're a corporation or an LLC, and there's a few more instances in which case you can be personally liable. So for instance, you purchase insurance to protect you, and the insurance either doesn't cover you enough, the insurance doesn't cover you enough, or they deny your coverage completely. So you are risking that you're going to still be held liable, or a percentage thereof. That's what you want to be considered of. The next thing is under what's called the alter ego doctrine. If you use your corporation as a personal piggy bank, and it looks like a person instead of a business, so if it's treated like it's your personal thing, so you pay your personal rent out of it, you pay personal expenses out of it, then that will negate it can negate your liability, limited liability. Now, if you purchase one minor thing, that will not destroy it most of the time. You've got to use it seriously as a personal piggy bank. It's got to be, the idea being that they don't want to give a limited liability if you're just going to treat it like it's you anyway, if it's a person. So you have to be super careful with the alter ego doctrine, that it's not, that it doesn't hurt you by buying lunch if that was not a true business expense, or paying some bill out of your business account when you should have been paying it out of your personal account. The best thing to do in that instance is to transfer it or pay yourself and then pay it back, and then pay it that way. So you want to make sure that the money is going from your business to your person if you're in that type of entity. And then you're going to pay that bill out of your personal account. So that's number one. Number two is if you have insufficient assets within the business to cover the debts, then you may be held personally liable for a judgment if you are sued. Okay. So you want to make sure that your assets and your liabilities are balanced and fair, and that you keep enough assets in the business in order to cover those debts. You don't want to basically funnel everything off to your personal account and then hope that when you get sued that they don't catch it. That's a good way for them to pierce the corporate veil and get at you, because in the interest of justice, it shouldn't be that someone that sells allows debt for a corporation or LLC, that they're harmed because you took the funds out of the company. And one more way is fraud. If you use a company to commit fraud, if you intentionally misrepresent your company to others in any way, they will, or they may pierce the corporate veil to get to your personal assets. So there are a lot of ways that, these are the top ways that they can get at your personal assets that you want to be careful of, because you don't want to risk that your business is going to be harmed, or that your person is going to be harmed for the sake of your business. And so you want to make sure you keep in compliance with this. Again, perform as a reasonably prudent person. Don't personally guarantee anything. Avoid using your corporation as a personal asset. You want to make sure that it stays as a business. You want to make sure you have enough capital in your business, have enough of funds to cover your debts, whether it be, monetary, or whether it be, a house, a car, whatever, fill in the blank, whatever the purpose of your LLC or corporation is for. Make sure that there's enough assets to cover your debts. And obviously, and this is probably the most important part, is make sure that you don't commit fraud, don't steal, don't intentionally misrepresent yourself or your products or your business, and you should be fine. So if you have any questions or would like to talk more about this, these are not all inclusive. There are potentially more areas where you could be personally liable. And the whole point of this video is to help you understand that just because you have these mechanisms doesn't mean that you get to just kind of do whatever you want. They're tools that are given to you, or that you're allowed, as a way to encourage investment, as a way to encourage you to protect your assets from these things. So when you look at it in the context of what it is, you want to make sure that you're following the correct law, that you're following the things that you should be doing, and that you're complying with corporate formalities. That's another way. Just remember that. See, I told you there's more. You want to make sure that you're complying with your corporate formalities, because the and that's true of a corporation. An LLC is different. So an LLC doesn't have the same corporate formalities as a corporation does. But you want to make sure that you're complying with these things, so that when you are, if you're ever, the purpose of an LLC or corporation is to lower your risk, to encourage, like I said, investment. If you aren't careful, then in these instances, you can be personally liable. By keeping your head on straight and acting as a reasonably prudent person, you're going to protect your assets and mitigate and lower that risk to an acceptable level. If you have any questions or would like to talk about this further, feel free to leave them in the comments. In the meantime, don't forget to subscribe and like and hit that bell button so you'll get notified every time that I go live. And we will talk to you in our next video.